Okay. Are we back?
Yeah, it looks like it says live over here. And BB, just get for as a backup, will you just hit record, that record button at the like on the bottom of your
God, Eve, you're asking a lot.
I know. I just want to make sure.
Where
Thanks,
is that?
everybody. Have a great class.
Where is that record button? There it is.
Perfect. You got it. Okay. You guys are good. Thank you, everyone.
Thanks, Eve. All right, so this is the newer version of where we were earlier. We just reviewed the SLIC, the Seller's Listing Information Checklist. And then we also have, if you don't use that form, SCMLS has another form that you can get at their website. And it's the same form, but basically the seller needs to initial all those three things at the top of the page, and you fill out everything here on the bottom of the page. So it's about 50-50. I get most people use this form and other people use the other form within zip forms because it's just easier for them. And again, I don't care what it is as long as it's used. That's all we need. All right, sorry.
We actually have both of those forms preloaded if you're using the Metro templates, so you can use either one. The primary difference why some people use one versus the others, the excuse me, the SELM form is a zip form template, and so it pre-fills, whereas the SDAR or SDMLS form, you have to fill in the information manually because it's a PDF, not a template in zip forms.
Thank you, Mark. And then before we move into the other forms, the other form that is probably the most important form is the AVID, the Agent's Visual Inspection Disclosure by the listing agent. This should be done at the time you list the home. So just get your AVID done at that time when you're in the property and get that form done. And there's a reason why. It's the dirty 6, right, Mark? Is it 5 or 6 forms now? It's 6. There are 6 forms that are necessary in a transaction that's called the dirty 6. The dirty 6 basically says, if that form is missing and was never provided, there could be an ability for a buyer to cancel the transaction without losing their deposit, even after they have removed all their contingencies. And one of the forms is the AVID, that's the Agent's Visual Inspection Disclosure, because that needs to be delivered with the TDS, the Transaction Disclosure Statement, at the time of the disclosures go out. So just do it early on in the business and in the listing and get it over there to them, okay? All right. So let's get into then the listing agreement, because this is the bulk. Did I cover as much as I needed to, Mark?
Yeah, I mean, we could, go on at length on all of those topics, but for now, if anybody, has a specific question about a specific, thing in the initial docs, just let us know offline and we'll explain it further.
Okay. So when you have the templates that are already preloaded into your zip forms, you'll have all these forms that will be in your transaction template. So don't worry about, well, where do I need to bring them in? No, they're in the templates. If you've set up your zip forms through Command, through DocuSign, everything will be in there. You just have to download the templates and then you're good to go. And Mark, do you have a date that the templates will be updated?
I hope to work on it tomorrow with Clarissa and see if we can get them knocked out. So we may be able to release them by the end of the week, but you can still continue to use the current templates that you have. The The new forms will populate. The only thing that won't populate is if they're, excuse me, the new versions of the existing forms will populate into your transaction. The only thing that will not is a brand new form that hasn't been added to the template yet.
Okay, so moving in now, this is the paperwork that the seller, you're gonna have the seller sign at the table, or maybe you've docu-signed it to them because you're so good, you got a listing, you didn't even need to go see the property. They just called you and said, list my home. In the beginning of every packet is agency disclosure. And we will talk about this on Thursday in more depth, but the agency disclosure is a form that actually needs to be signed even prior to when you're taking the listing. So when you come across a client that you're going to do business with, whether it's a listing agreement or, and typically this is in the case of a buyer agreement. Very early on in the relationship, as soon as possible is the way the law is written, as soon as possible, you should be able to send this form or have them sign in front of you. And all it is a disclosure, and it defines what agency is. There's two types in the state of California, but you are required by the state of California to disclose agency to any new principal that you may be bringing into your business, okay? And we'll cover that in more detail on Thursday. The other form that is new this year, it came out 6/22 or updated 6/22, and you can always tell when a form's been updated if you're in the current version by looking at the form, and below it you'll see car form FHDA, and I have a date. That's the date the form is updated. And this form came out actually last year or in 2020. It's the Fair Housing and Discrimination Advisory. This was the result of the 2016 through 2018 rise in fair housing violations because of what was going on politically. And California, which is very forward, wanted to get this form put out there. And really, fair housing is something that I wish agents knew more about, but there's like 216 different words you can't use in some of your marketing and advertising. And the fines and violations for a fair housing discrimination can be in the thousands of dollars. So for an example, when we're talking about fair housing, back in the days, we used to have redlining, where we would direct people into certain areas of geographic area because there's all these ethnic varieties in that area. Or you can't even have Jewish people buy into a country club estate because it was written into their bylaws. So all that stuff has gone out, is now gone, but there's still some of it present today. The next form is the PRBS, the possible representation of more than one buyer or seller. And it's actually a disclosure, but it's also a consent. Okay, and the consent meaning you're now taking this listing from the seller, and the seller is going to trust you to get the home sold and put on the market. But you as an agent and us as a brokerage might actually have a few things in common. We actually might have other sellers in the geographic area that we will be representing. So what this is saying is putting the seller on notice where it says multiple sellers, hey, we're going to take your listing, but we also might say, for example, take your neighbor's listing, your neighbor across the street. And we're going to act fair and do our fiduciary duty to you as well, because we're bound to that. And we're going to give you the same type of marketing, et cetera, as we would any other type of seller. We're going to treat everybody fairly. The PRBS also represents, buyers as well too. You might have 3 to 4 different buyers in your buyer pool, and then each of those buyers might be identical type of buyers, meaning they're both looking in the same price range, the same neighborhood, et cetera. And so how are you going to treat them fairly? And this is the form that says you're giving us consent that we might have a buyer we represent that could be exactly like you in regards to your price range and your wants and needs and desires. And then the third part of this form is dual agency. If a seller is represented by the broker, the seller will acknowledge that maybe a buyer might come from within the buyer pool within our own brokerage with another agent. And that's what dual agency is, where we represent both the seller and the buyer in a transaction. And you're giving us permission for that to be okay. So when we take it to market, you're okay if we bring a buyer and one of my cohorts at KW Metro finds the buyer. The next form is the wire fraud and electronic funds transfer advisory. This is an important form mostly for buyers because it's buyers that are going to wire money into escrow more than sellers will, okay? But you need to advise them on the wire fraud and electronic funds. And this is a form that you just don't breeze by. You really, anytime you see a form where there are some words that are bolded, that's the important part of the form. So wire fraud basically happens when somebody can tap into your email and find out that you have a transaction. And mostly it's coming from Russia and China, where they're tapping into your emails. They see you have a real estate transaction, and now they're going to sit in the background and watch the emails as they go back and forth. And I'll give you an example about how wire fraud almost happened at our office. It was actually one of our top agents. She got an email, or her client got an email, a buyer she represented got an email that looked like it came from her. And the email said, "Hey, Joe Buyer, I just want to let you know the final part of the deposit is due today. It's $25,000, it's X amount of dollars. Please wire it to this account. I'm in a class until 2, so I can't help you. So I'm going to send you this email." And basically what they're doing is they're mimicking the agent because they might change an email by maybe one letter. So instead of saying Joe Agent, they'll be like Joe Agent 1 at gmail.com, which is why you should be using your KW email addresses for all of your real estate deals, because there's multi-factor identification already embedded in a KW email address. There's already security measures put in place. You should not be using a personal Gmail account or Hotmail or Yahoo. And by God, please don't be using an AOL email address. If I see you using AOL, I will call you out and say, this is 2022, it's not 1994, okay? And it's really mostly about the security on it as well too. So please start setting up all your stuff for your real estate business with your KW email address rather than a personal email address, okay? And this wire fraud advisory basically gives the 5 steps that a person needs to do. You yourself should have multi-factor authentication set up on your KW email address, as well as if you're using a personal account, but I highly recommend don't you do that, okay? And if you don't know how to do that, you know what? There's this really great thing called Google, and you go to Google and say, how to set up multi-factor authentication on my personal email address. And it'll give you step-by-step instructions. Okay. Oops. Why did I close that out? I have no idea why. Okay, now we're into the listing agreements. Okay. Date prepared. We're taking the listing today. The seller's name is Joe Seller. That auto-populates because I filled his name into the SLIC form. So anytime you fill in information that will be duplicated in other forms, it automatically auto-populates every other form. Grant, Keller Williams, San Diego Metro. We're the broker, right? Not you, you know, put your name there. And we're going to take the listing on 6/21, and we're going to end it September 21st. So we're going to do a 3-month listing. So the question always gets asked, how long should you take a listing for? And in my mind, you can take it as long as you need to based upon how long you think it's going to take to get the listing sold. If you take a listing that you know is overpriced and the seller is adamant for that price, but you know you're going to have to work on some price adjustments down the road, then take it for 6 months. If you take a listing to market that you know it's really a good price and it's in a good area and it's a great home in relationship to all the comps out there, and you know the buyers are going to gobble it up, you could easily take a 3-month listing. You could take a weekend listing. It's a lot of work, but it's a tactic that we used in markets where we went to maybe a for sale by owner. And a for sale by owner didn't really want it to get locked in to a 3-month contract or a 6-month contract. Say, great, give it to me for a week. Let me have it for 1 week. And if I can't sell it that 1 week, then you don't owe me anything. Now, it's a lot of paperwork to get that done for that seller for 1 week, but you can do it. And we get asked that question all the time. Mark, what do you see? Because you review a lot of the listing agreements. Are you seeing 3 months, 6 months?
In this market, it varies. I see some for a year, believe it or not. And I can't think of any property that's been on the market for a year, but yeah, I think generally about 3 months. There are some types of transactions that have a, like probate, for example, can't be longer than 3 months for the initial listing period. So, but typically a typical listing 3 to 6 months. But if I was in the listing agent's meeting with the seller, I would say, well, there's a possibility that the seller or the first buyer that we have might not complete the sale. And so then we need some time to, regroup and start over. So in that sense, you don't want to leave it for a month or 2 months, maybe 3 to 4 months is a better choice. It can always be extended.
So glad to bring that up, Mark, because I've always wondered, what if in that situation that you just mentioned, what if it falls out of escrow, we need to start over again? So that you answered that part. What if we were to get into escrow sometime during escrow is going to be the expiration? Would we renew it just to be safe? Or does that not count?
What you would do is extend the listing period end date, not renew it.
That's what I meant. Yes, exactly. Yeah. So would I extend the date? Okay.
Yeah, you'd use a form called modification of terms. The acronym is MT, and you would just say the new listing expiration date is. And it's a good thing for you all to put on your calendar when you take a listing, to put the listing expiration date in there, and maybe a tickler for 2 weeks beforehand, so that you're not caught off guard that, oh, it expired and now we have to start over again.
Awesome.
Mark
Thank
brought
you.
up a point about probate. Mark, will you say the thing about probate? Well, basically, if you have a potential for a probate listing, you need to call us for guidance. They're not regular listings.
Yeah, there's a lot of complications with it. Was there a question in the chat about probate? I didn't see.
No, I just want to make sure that if people are doing, if they have a potential for a probate listing, that there's going to be nuances that they may consider bringing in a probate listing type of agent that's done that before. Especially if you're brand new, because there's a lot of court related issues and different documents, et cetera, that require probate. And it really is it's a specialty. It's a specialty that not every agent understands the nuances of. And we've had multiple probate sales this year that have been very challenged. And we were on the buy side actually in a lot of them, but fortunately there was a good listing agent on the other side that knew how to navigate through the probate related issues. One of the things I forgot to mention, and we'll cover this at the end, but you notice I put the name of the individual, the seller, as an individual name. So this brings up a point about how do you take a listing when it's in the name of a trust. or a corporation or a LLC. Well, there's this form that was used in the past called the representative capacity, RCSD-S for seller, that showed who had ultimate authority to sell this home. So any listing you take, know that if it's more than two people or three, more than one person on title, all individuals have to sign the listing agreement. So if there's two or three, you have to put every one of them on the listing agreement. If it's in the name of a trust or an LLC or a corporation, then you need to incorporate the RCSD-S, which is the representative capacity form that shows who has the authority to sell that property. And how do you
actually,
know?
Robert, that process is changing now
Yes.
with the release of this form.
Let me
So-
just cover this one part, Mark, and then you can go into changes.
Go ahead.
How do you know if it's in the name of a trust? Well, that's because prior to your appointment and prior to you taking the listing, you've pulled up the tax records in the MLS and looked to see who has title for that property with the tax records. And if you see anything that says LLC, trust, irrevocable trust, you now know that you got to figure out from the person you're going to meet, you're going to say to them, hey, you have trust documents, and within your trust documents, I need one page of that. I need a copy of it. And it's called the abstract of trust. Can you please make a copy of that abstract of trust for me? Because that's how I need to make the listing agreement. And I have to put that name, the abstract, however it's written on the abstract of trust, I need to put that to the listing agreement. Okay, go ahead, Mark.
There's equivalent documents to that. These documents that, like an abstract of trust, sometimes called a certification of trust, they are all generically referred to as evidence of authority. Okay, and it's in the listing agreement and in the purchase agreement, it's defined what that is. But essentially, for a trust, it would be the certification of trust or the abstract of trust. And on that document, it's not the whole trust document, it's a portion of it that says this person can buy and sell real estate, or these people can buy and sell real estate on behalf of the trust. Similar concept for an LLC or corporation. They may have multiple officers in a corporation, members in an LLC, and they have to also provide you with something called a resolution. If there's more than one officer or member that says, hey, we all agree, all of the people that are members or officers of this entity, to sell this property. So when you run into those situations, reach out to Robert or I, and we'll help you with them.
How many transactions do you deal with, Mark, each and every day?
20 to 30 a day, at least.
That you have to go through and do the abstract of trust.
No, with the ones that require evidence of authority, there's probably about, I'd say 30 to 40% of them right now.
And we bring this up now because what happens is you've got to backtrack then and go get new documents filled out. Because if it's in the name of a trust and you took the listing in the name of the individual owner's name, that trust is the controlling document that allows that person to sell that home. And if it's in that trust, you don't have a valid listing agreement. So if we need to defend it, we can't. But you need to make sure whoever has authority to sell it can sign the listing agreement and sell it. Okay. And this is the change that Mark was talking about under entity sellers. So it's on the last page of the listing agreement, page 5 of 5. You would check this box, and then based upon the representative capacity, what it says on it, you would then put the legally authorized signer's name there. And it will be written on that abstract of trust.
Priscilla has a question, Robert, in the chat that says, can a person sell if he has a power of attorney? The simple answer is yes. A power of attorney is a legal document that allows a person to grant to someone else the authority to act on their behalf. And this is common in like military families where one spouse is deployed and the other one has to sign on their behalf and so forth. It's also in estate, common in estate planning as well. So the simple answer is yes. The thing that you want to make sure is that the power of attorney is relatively current and hasn't been revoked. Otherwise, it's no longer valid.
Thank you, Mark. And then, so then the next part is you put the address, the city, the county, the zip code, and then of course the assessor parcel number of that home, because, and where did you get it? Where'd you get that assessor parcel number from? From where?
The multi-listing.
Well,
Well,
it's
you
not
got
in
it.
the listing. It's not in the listing service yet. This is a
Right.
listing agreement.
Oh, okay.
You actually got it from the tax records when you logged into your MLS and you looked it up there. Does everybody understand that? Want to make sure we do that before we move on. And again, don't be afraid to ask a question like, what are you talking about? Where is this?
Can you repeat that one more time, please?
So you should pull the tax records and you go into your CRS tax data in your MLS login. You'll see it's like a yellow button that has all the tax records in it. You put in the property address and it'll show you everything about that property. If it's in a trust, who's the sellers on title, etc., as well as the assessor parcel number. So you need all that printed out really before you even start the listing agreement.
Robert, you think that that is a better source than actually the County of San Diego Treasurer's Office? Or I guess they're equivalent, but which one's simpler to use?
Well, it's the same thing, Mark. It's a, oh, you mean go to the actual treasurer's website rather than through the MLS?
Exactly, right.
I've never done that, but
I'm
yeah,
gonna drop,
I guess that's another avenue.
I'm gonna drop that link just in case people want to take a look at it.
Okay. And then next box is this property is a manufactured home. This isn't. But if you check that box, it will bring in a form called Car Form MHLA. If you do ever take a mobile home listing, it's basically like selling a car. It's not like selling a house. And you do it through the state franchise tax board. So nuances, if you take a mobile home listing, reach out for guidance so that you can get the proper guidance. And then this box here, this property is being sold as part of a probate, conservatorship, guardianship, or receivership. C for probate listing addendum and car advisory PLA for additional terms. If I check that box because it's a probate sale, then it would incorporate other forms within the listing agreement. Next thing, 2A, we're going to enter the price, $675,000. And then item B is listing terms. Listing terms can be anything. Listing terms could be, I don't know. They want to make sure that the grandma chandelier in the dining room doesn't get sold, even though that would go into items excluded on the following page. But it could basically be anything that would be a term like no showings on Wednesday, or no showings between, only showings between the hours of 10 to 4, Monday through Friday. Those could be listing terms that the seller and you agree to in advance. Okay. Mark, you review a lot more listing agreements. Do you ever see anything in the listing terms other than maybe a
Yeah, there's occasions where there's a variable commission set up in there, or there's a exclusion for a particular buyer. I mean, an exclusion for a buyer, or the listing terms might be specific to a buyer. We've seen listing agreements where the two parties, seller and buyer, wanted to get together, and so in 2B they said this listing agreement is only valid for offers from Mary Smith, who was the intended buyer, and that way the buyer could sign, or the seller could sign a listing agreement and not feel like it was going to go to open market if Mary Smith offer didn't go through. Whenever you run into a situation like that where you've got something special or unusual, just reach out to us.
All right, the next section talks about compensation to brokers. The amount of real estate commission is not fixed by law. They're set by each broker individually and may be negotiated between the seller and the buyer. Okay. That said, we are not a discount house. In other words, you can't go out and advertise 1% listings as an advertising mechanism in order to attract sellers, because it's against our franchise agreement with Keller Williams. We're not a discount broker. But there are times from time to time that you might need to take a listing for less than 6% in order to get the listing. And that's a case-by-case basis. And most agents that are capped might take a listing for less than 6% and pay the other side a little bit less. But as a standard of practice, I always say the 6% is what you should take most of your listings for, especially now that we're entering into a time where things aren't flying off the shelf. Stephen does a really good job of presenting your value in script practice. And I believe an industry as a whole would be I think 6% is a deal. I really think it should be 10% because of how hard you work to get a home sold. But that said, 6% is where the standard should be. And our industry would probably get 6% if the industry would learn how to overcome commission objections. And that's the scripting. That's all scripts. So that's why we do scripts daily. So hopefully you are attending Stephen's language of sales scripting class because we bring up some valuable stuff in there. So at this point, it's going to be 6% of the listing price, or you can do a dollar amount, or you can do an and. And the and would be, let's say the seller would say, well, if you can get a buyer, if an agent will come bring a buyer, I'll pay that agent $2,000 as a bonus or $10,000 as a bonus. So you would put $10,000 right here because that's what the seller is willing to pay, the additional $10,000 as a bonus if an agent brings a buyer within the first, let's say, 14 days.
Or a certain price level is achieved.
Or yeah, a certain price level is achieved, okay? That's what section 3A covers. Section 3A2 is where we protect ourselves as a brokerage. And it basically says this: if within, and I put 90 calendar days after the end of the listing period or any extension, or after any cancellation of this agreement, unless otherwise agreed, seller enters into a contract to sell, convey, lease, or otherwise transfer the property to anyone, like a prospective buyer or that person's related entity. And this person has to have physically entered and was shown the property during the listing period or any extension, or a cooperating broker, or for whom broker and any other cooperating broker submitted to seller a signed written offer to acquire, lease, exchange, or obtain the property. Seller shall have no obligation of paragraph 3A2 unless not later than the end of the listing period or an extension or cancellation. Broker is given seller a written notice and names of such prospective buyers. Okay, I just did a bunch of legal language, but here it is, easily what it says. You have a listing. Let's say it's for 90 days, okay? Because I did it for 90 days up here at the top. And that listing expires, you couldn't get it sold. And the day after that listing expires, you have a duty to give a list to the seller of everybody that entered that property during the time you had that listing. That's why you keep track of every showing and every buyer and all the names that are coming through. And if that seller after the listing cancels and they decide to sell it to one of those buyers, we can still go back and claim that commission. So here's an example. You're on the 89th day of this listing. A buyer pops up, knocks on the door, and is brought by another agent to see that property. And that seller says to that buyer, prospective buyer, hey, come to me tomorrow because my listing expires and I'll go ahead and we'll negotiate a deal. It's to prevent kind of like that type of stuff happening. so that you can make sure that you get paid, because during the listing period, you presented that you marketed the property, you advertised, and you got people there. So it's trying to prevent sellers from going behind your back after the listing either canceled or expires, to get some of the buyers that actually came during the listing period, because you need to be rewarded for your efforts, which is basically what they're looking for you to market the property and bring buyers. And this paragraph kind of protects it. They would also be responsible to pay for item number 3A3 if, without the broker's consent, that the seller decides to withdraw it from the sale, conveyed, blah, 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 or make it unmarketable by a voluntary act of the seller during the listing period. In other words, where this could come into play is if the seller is in escrow with a buyer with your listing during the listing period, and that seller decides to breach the agreement and say, I'm not selling. And now they're in breach of the agreement with the seller, but they're also in breach of our listing agreement with the buyer. They're also in breach of our listing agreement between the seller and the brokerage, and they could be responsible for paying. That's what the 3A, 1, 2, and 3 cover. Are there any questions on that one? Okay. Item B talks about if the completion of the sale is prevented by a party to the transaction other than the seller. So let's say the buyer breaches the agreement in escrow and the seller decides they're going to sue that buyer because they are actually able to prove financial harm through the transaction. And they take that buyer to court and they recoup damages. Well, then this paragraph basically talks about the amount equal to the lesser of 1/2 of the damages after first deducting title and escrow expenses and the expenses of collection, if any. So it's a small amount. And I'll tell you, 99% of the time, I don't think there's any broker in San Diego that have actually gone after a seller after they are awarded judgments, but it's there to protect you. And then item C, in addition, seller agrees to pay broker. You can also put that, this section right here, remember I talked about that $10,000 bonus? You can put it in this section as well too. Section D now talks about the cooperating broker compensation. Up here was the full 6%. Now we're going to put it on the MLS and we're going to offer a percentage to agents to come in and show the home that are members of the board, the MLS, and we're going to pay them to do it. And that's what this paragraph states right here. So we're going to take it at 3%. In other words, we're going to pay any cooperating broker 3%. Here's what happens. We see this a lot. I wouldn't say a lot, a few times. Some agents will think that this section up here is what the broker is going to keep. It's not. It's what the broker is paid so that they can then pay out the cooperating broker. So if you were to put 3% here and 3% here, what does that mean? Anybody want to take a shot?
I know.
6%.
That means you're working for free.
Yeah, it means you're working for free. So don't make that mistake. Make sure that you get a contract signed with 6% is the full broker commission, and 3% you're going to give to the other side, half of it. Okay.
This is sometimes confusing because sellers will look at that and they'll go, well, am I paying 9% or am I paying 6%? And your answer is you're paying 6% because when you read 3D1, broker is authorized to cooperate with and compensate brokers. So in other words, we pay the other broker, not the seller. The seller pays the 3% or the 6%, and this split portion is paid by our brokerage to the other brokerage.
So if you're ever asked that question, Mark just gave you the answer. Am I paying 6% or 9%? And Mark says, no. If you read, broker is authorized to cooperate with and compensate brokers participating through the MLS by offering the compensation of 3%. We're paying it. The seller's not paying it. Seller's paying us, and then we pay the other side.
Right.
Item E, seller irrevocably assigns to broker the above compensation from seller's funds and proceeds in escrow. Basically says, okay, we're going to submit everything through escrow. Broker Bob's going to sign a commission, a CI, commission instructions that the escrow will send me that allows these us to be paid through escrow. Item F, 1, 2, and 3. Seller represents. The seller has not previously entered into a listing agreement with another broker regarding the property unless specified as follows. So let's say you have a listing that you're taking, but it was already listed with another brokerage prior to this. And that broker may have a claim that they would be owed money from a particular list of buyers. So remember up there, I talked about that 90 days after a listing expires or cancels or is taken off the market, that we could claim within 90 days if we provide that buyer, that seller with a list of all the buyers that came in. Well, this seller might actually have the case now where they have a list of people that's represented by the previous brokerage, that if any of those people from that list buy the property, then they would owe that other brokerage the listing commission. So this is where the seller can exclude that other brokerage because they might be under contract still or have contractual terms from the previous listing that they were with that they would owe money in case one of those buyers were to purchase. Item 2 talks, does everybody understand that? Like clear on that? Okay. And then item 2 talks about that the seller has warrants that the seller has no obligation to pay us money if we're going to sell it to somebody that we're going to put on this list right now. So I'll give you an example. You have a list, you take a listing and the seller says, you know what? My cousin talked about buying my house and they went out, they're getting pre-approved to see if they can afford it, but I still want to take my home to market. But if by the odd chance they still want to buy it, I still want to sell it to them. So you can list their cousin in item number 2 that basically states, hey, if your cousin comes and decides they want to buy and you want to sell to them, then you won't owe us any money either. You can go ahead and sell them. And we won't represent you on it though. And item 3 basically talks about that where it says if the property is sold to anyone above in item 1 and 2, then the broker is not obligated to represent the seller in the transaction. So then we just wash our hands and wish them well and say goodbye. Don't see a whole lot of those, do we, Mark?
No, but it brings to mind one thing that I see occasionally where agents are trying to answer a question the seller has, and they end up drafting a clause that says something like the seller may cancel this agreement at any time without any obligation. Well, guess what? That's not a contract. You know, if one party can unilaterally cancel without the other party's approval, that's not a contract. So you can't put clauses like that into agreements. So again, when you run into that, ask for help.
All right, moving into section 4, items excluded and included. So in real estate, there's a definition of real property and personal property. Does anybody know the definition between the two? What is real property and what is personal property?
One's attached and one isn't.
Was that Francisco?
Joseph.
Joseph. Ding, ding, ding. You got the prize. Good job, Joseph. So real property is attached. Personal property is not attached. So when we have this section called included and excluded, excluded would be something that would be real property that the seller wants to take with them. So it's clearly defined. If it's attached to the property and the seller wants to take it with them, or if there's any question whether it's real or personal. So I'll give you an example of what could be excluded would be the washer and dryer. Most sellers, at least in California, not in Chicago, but in California, they take their washer and dryer with them. Or they might want to take their nice stainless steel refrigerator with them. So this is where you would define the appliances that would be excluded. In other words, the seller's going to take them with them. Also, what could be excluded would be that chandelier I talked about earlier in the dining room that is a family heirloom. A chandelier is attached to the ceiling, so it becomes real property, not personal. But they want to take it with them, so you would mention it here as well too. So I'll put chandelier. That would be an example. And then items included.
About something like sheds in the backyard or something like that.
Would be something that is considered personal property or could be quasi-personal property. We run into a lot of this with like water fountains. Water fountains technically are real property because they're attached to the land because they're hooked up to electricity and they're hooked up to the water valves. Okay, so there's a case that could be made that a spa or a water fountain is really real property. But this is where you could really save a lot of time, energy, and effort and headache is to have those conversations, recognize the nuances of the property and know, I need to get clarity on this. Are you expecting to take this water fountain or not take the water fountain? Are you expecting to take the above ground spa or not take it? Because if so, then that's how we're going to market and advertise the property. So when buyers do come and make offers, they're making the offer based upon what they think. And I probably get 5 to 6 phone calls a year where we've closed escrow on a property and the buyer comes back and tells our agent that the seller took the water fountain. Since there wasn't clear definition of it, then we had to go through the contract documents to figure out, was the thing attached to the land? Was it put in the marketing and advertising, et cetera? Sometimes the listing agent advertised it that way and the seller took it anyway. Good example I can remember when I first got in the business is those old-fashioned toilets where the water tank was way up on the ceiling or way up on the wall and then the commode was down and you pull this chain. Well, there was a escrow that we closed that the seller actually took that toilet. And the toilet actually is real property. It's attached to the land, so you cannot take it. But if we want to do included, we'll put above ground spa.
Electric vehicle charging equipment. Water softener.
Okay. And seller intends that the above items may be excluded or included in offering the property for sale, but understands that the purchase agreement will supersede it. So let's say that dining room chandelier, a buyer really liked it and they wanted it, and it's in the purchase agreement and they've signed it, that chandelier stays with the property. And we've had that happen a lot too, where the seller was expecting to take it and then they didn't know that they signed in the purchase agreement that the chandelier goes. This actually played out for me once in the MLS. I was representing a buyer on a small condo, and the MLS actually stated refrigerator does not convey. But in my offer, I asked for the refrigerator the seller signs it. 20 days into escrow, the transaction person on the team that sold to my buyer this condo calls me and says, the sellers want to know if your buyers want to buy the refrigerator. I said, well, we put it in the contract. And she says, but the MLS stated that it didn't convey. I go, I know, but you signed it in the purchase, the seller signed it in the purchase agreement. She goes, I'll get back to you. So they went through their purchase agreement documents and they found out, oops, they didn't really go through their offer properly. And they found out that the buyer did ask for the refrigerator and the seller signed off on it. So
Yeah, the takeaway on this is that if you ever see anything that says per MLS, the MLS is only advertising. Remember that. Just commit that to memory. The MLS is only advertising. It is not an agreement between the parties.
Leased or lien items. Mark, can you go through this section? I need to give my voice a rest.
Okay, no problem. Yeah, basically this section, you're there, you're viewing the property, and you may notice something like a water softener, or you may notice that they have an alarm system. Propane tanks a little bit less common, but that's in outlying areas that can be an issue or an item. But probably the big one that we all see are solar power systems, and they may be fully paid off by the seller, maybe free and clear, or they may have to be paid off as part of the transfer. And then the lien item section, that could be items like maybe they had the house retrofitted with windows and they have some type of a loan on that. Again, that's something that has to be addressed, and questions that you as the listing agent need to ask when you're on the appointment. Are these owned, or do we need to be paid off? And then another proactive thing you can do is the last sentence in section 4B, where it says, obtain copies of these agreements and documents. One of the things that causes a lot of problems and delays in closing are transfers of these solar systems from seller to buyer.
And if there's a PACE loan on it. So do yourself a favor, if you take a listing where there's leased or liened items, and Mark was saying it's mostly with solar systems, get that paperwork early on and get it to your escrow officer for them to start searching and figuring out what the payoff is on that. There's a lot of pitfalls with these leased items with solar as we're entering the 10 and 20-year mark on some of these items. In some cases, the seller has to pay it off, or it could be conveyed. And it could be a real quagmire. Item 5 talks about what the MLS is. So basically what this section covers is, hey, we're a member of the MLS. We're going to put your listing into the MLS and market and advertise it. And you're allowing us to do that. That's basically what section A is. And section B, we're going to give all the information to the MLS, like the sale price, the financing applicable, terms approved. Even if the property was not listed with the MLS, seller consents to broker provide a copy of this listing agreement. This whole section just basically outlines that we're going to put your property in the MLS. Okay. And then Mark, I see in the drop down, it is SCMLS, CRMLS right now, right?
Yeah, that's correct. Those choices that are there are just specific to Robert's own personal account, previous entries that he had put in that field. So those are not always going to appear in all of your accounts. But SDMLS/CRMLS would be the correct thing to put there.
And then item 6, benefits of using the MLS and the impact of opting out. If you have a listing that you're going to exclude from the MLS, then you need to have the seller and you go through this section 6A, B, C, and D. And then the seller needs to initial this section, and the broker, I need to initial, you need to, not me, you as the agent need to initial a section as well too.
Yeah, this section is
Basically-
always initialed, and again, the agent can initial that one that says broker agent's initials, that you can do that on behalf of the brokerage. But always,
So-
that section 6 is always initialed.
Thank you, Mark. And it really just basically says that the MLS is a powerful tool, and this is the way to market your property. You will have, I have an agent right now that has a multi-million-dollar listing, but the owner doesn't want to put it in the MLS. So he doesn't really have a listing agreement. It's kind of a soft listing. But it's really hard for him to go market that property if he can't advertise it. He can't put it on Facebook. He can't put it on any type of social media or run ads on it because he's a member of the board. If you're a member of the board and you have a listing or a potential listing, you have to have a listing agreement, but then you also have to make sure you're duly authorized to market and advertise it. Section 7 covers the clear cooperation policy that we talked about earlier. So basically what the clear cooperation policy was in the market that we are in the middle of and we were running up to it for the last 10 years, NAR, the National Association of Realtors, made this decision that they had to make it fair and equitable for every agent in the industry to be able to present their offers or present the homes that were available for sale to their clients. And what they were attempting to do was to prevent agencies or brokers or individuals from trying to double in transactions. In other words, they got a listing, they took it to market, but they really didn't take it to market, and they were really just trying to sell it themselves. The clear cooperation policy was intended to clear that up. Our MLSs that we are a member of are part of the clear. We do require the clear cooperation policy. And then if item B discusses what type of marketing do you need to do within the clear cooperation policy. Now, I won't go through this form, but there's another form that the MLS put together that explains the clear cooperation in layman's terms. And then also item C talks about coming soon status and how do you navigate through the coming soon status. And we are, this section basically says, hey, you're authorizing us to be able to use the coming soon status because it's kind of pre-marketing. So you have a listing that is in coming soon status. You take the listing and the coming soon status is available for 21 days in the MLS and it converts to active. But within that 21 days, it's basically you're marketing the property, but you can't show the property. You're just gaining attention of the property. And I think you'll see a lot more coming soons pop up. The minute you show that property, if it's in coming status, it has to go into active status and make it widely available to the agent community. So remember that. If you have a coming soon property, you can have a sign. It has to be in the MLS as coming soon. But the minute a potential buyer steps in that property, then you've got to make it active.
Robert, I dropped a link in the folder, or in the chat rather, of the KW Metro Associate folder, because a lot of these things, if you want more reading on any of them, we have documents in the compliance portion of that folder that explain in greater detail what the clear cooperation policy is and so forth. So you can, look at that and find some additional information on that.
You said you put that link where?
I dropped it in the chat.
Did you put it to one person? Because I'm not seeing it in my chat. Or it's in an old one.
I did do that. I did that by mistake. I responded to one person. My apologies. Let me send it to everyone here.
So that link Mark's talking about, bookmark that because we put a lot of documents in there that would be necessary for you to have at any one time.
And a lot of this link is specific to Metro, so the people from Signature can look at it too. It's nothing in there that's like, hidden or anything like that, or special proprietary. We just don't have an equivalent document for Signature yet.
And then item D, seller instructs broker to not market the property until, and then you put the date here. So if you're not going to market it till the 30th, you'd put it right there, and that's the date that you put it in the MLS. And then 7D2, seller instructs broker to not market the property to the public. Seller understands. So if they're not going to go, then that you would check that box. And then item E, whether you check box 1 or 2, seller understands and agrees that should any public marketing of the property occur, the property listing will be submitted to the MLS within 1 business day. So I said technically, if you show a buyer, it's got to go to the MLS. No, it's really the next day. It's with the next business day, it needs to be going active in the MLS. And then F, you'll never, ever, ever check box X. F, never. Because it does apply. So just cancel F. Item 8 talks about MLS data on the internet. And it also says, hey, we're going to put your property in the MLS. Once we do, it actually becomes property of the MLS and the local board. And there's nothing that we can do to pull that back. So that would be like pictures of the listing, et cetera. And then we can choose to opt out, but opting out, we're not going to get exposure to all the other sites that index stuff like Redfin and Zillow and Trulia, all those internet data exchange sites that go out to multiple services. It's all going to go out and be syndicated out to that. Also within that MLS data, there's an automated estimate of value that some sites will actually do that, like Zillow does it, Redfin does it, but we have no control over that. The only way we would have control over that if you were to opt out of putting it into syndicating out to other sites, but that would defeat the purpose of marketing it to a broad audience. But there are some instances like that. Item 9 talked about the seller representations, that there's no liens or judgments or lawsuits, or they have the right to transfer it, etc. Item 10. Item 10 basically talks about what the broker's and seller's duties are. The first part is the broker's duties, and that would be section A, B, C, okay? And in this section, it basically outlines the job description for you as an agent. We're going to help you order reports, put your disclosures together, advertise and market the property, disclose any real estate licensee, making an inquiry in the receipt of the offers, and offer the pricing of such offers. We're going to present offers. We're bound to present offers to you. So any offer we get, we're duty bound to present them to you. We're all going to make sure that we're not violating fair housing. You're going to tell us that you instruct us to not present buyer letters. That's new. The buyer letters are what we call the buyer love letters, where a buyer would basically say, we want to buy your house. We're a nice family. We've got 2 kids. And they mention their nationality. Well, that's a violation of fair housing right there. So this section 10C2 instructs the broker to, it's templated for the broker to not present these buyer love letters, or you can check box B, where you instruct the broker to present the letters. But you need to have a conversation with the seller about what the potential fair housing violation could be if you accept an offer where someone sent a love letter and that love letter was laced with fair housing violations. Item D says the seller agrees to consider offers presented by the broker. In other words, they have to, in good faith, look at all the offers that are being presented. Item E talks about the investigation and reports now that the sellers should be doing. And this says seller agrees within 5 days at the beginning of this agreement to order, and when required by a service provider, pay for a natural hazard disclosure report. So that's automatic. They have to buy the NHD. That's one of the reports that is the Dirty 6. that if they don't provide it, the buyer can cancel. But there's
How about
also
the
some,
big six, not the dirty six.
the big six, I call it the
Yeah.
dirty six. But there's also recommendations that we recommend you get a structural, a pest control report or general property inspection. Rarely will you check homeowner association documents because you don't want to order those up front. You want to wait till you get escrow. But a preliminary title, a roof inspection. Why do you want to recommend the seller get all those reports? Because it will bulletproof a transaction if the seller provides a third-party validation of a property inspection, and that property inspector basically said what is wrong with the property in their words, and then a buyer looks at making an offer, they can read that report and say, okay, based upon this, then I'm going to make my offer based on that, rather than waiting till I get an escrow, do my own report, and then find out there's all this stuff wrong with it. So it kind of bulletproofs the transaction to do that. Item 11 talks about brokers authorized to accept and hold on seller's behalf any deposits. We don't do that. We don't trust log. So it really doesn't apply for us. 12 goes through agency relationship. So not much there. Item 14 talks about, 13 talks about security, insurance, showings, audio, and video. 13 addresses if there is a closed circuit camera or like the audio video recording equipment, because it's illegal in the state of California to record, to videotape someone without their consent. So if the seller has stuff like that in their house, then the very last sentence says sellers advised to post notices disclosing the existence of security devices. Okay, so if they have a video camera installed that's for security, then they need to disclose that they have that in there by putting a small little sign up at the entrance or inside the house.
And that could extend to, maybe some of you are thinking, oh, this full video surveillance system in the house. Well, it could be a baby monitor in the baby's room. Same thing.
Section 14 talks about photographs and internet marketing. And this basically says, okay, once we take your listing, put the MLS, we're going to take pictures. And when we put those pictures in the MLS, it becomes public domain. We have no control to get that back. So the seller will acknowledge that. 15 talks about our lockbox, if you're going to put a lockbox on the property, or whether or not, if they don't want one and you need to be there for all showings, then you would check that box. But God help you if you have to be there for all showings. 16 talks about the seller authorizes the broker to install a for sale sign or a sold sign on the property. And that, of course, if the property allows it, if it's within an HOA community, you need to know the HOA community rules. 17, equal housing opportunity. We talked about that, again, anti-discrimination laws, but we offer this property in compliance with that. 18 addresses attorney fees. If any of us decide to go sue each other, this is how it will go. This is how we'll proceed with it. 19 could be additional terms. Mark has templated the affiliated business disclosure as well as the market conditions advisory.
One
And
thing
those would automatically come into your templates, right?
Robert, I believe that's correct. On 18, I think one of the things they changed recently is they made it seller and broker are each responsible for paying their own attorney's fees and costs, which I think previously it might have said the prevailing party. Yeah.
Yeah, that is right. I'm looking at that. I'm like, okay. That is new.
Yeah.
20 is management approval. That's why you got to submit this listing within 2 business days to Mark for him to go through the initial review. But your listings, I could reject them. And I rarely have done that, but we have to approve the listing. 21, successor and assignees. This agreement shall be binding upon seller and seller, successor, and assigned. So if the seller assigns this or they die during the listing period, it's still binding upon the seller, even though they're dead, by their successors. 22 addresses dispute resolution. If we decide to get into a dispute because you want to violate the terms of the agreement, et cetera, well, first we're agreeing to go to mediation because that's better than suing each other. And if we can't hash things out in mediation, we'll go to arbitration, and arbitration is binding because a person will make a decision as to what the dispute is and how it should settle out.
Actually, that's incorrect, Robert. We will do mediation and then.
That's right. Sorry. I was going on auto.
Yeah, this is something that changed a few years ago. The brokerages were given the option to participate in binding arbitration or not. And like many other brokerages, decided not to. And why? Because the finding, or the ruling rather, of an arbitrator is binding and there's no appeal process. So even if the finding had fault or was incorrect or not consistent with law, the party who had the judgment against them had no recourse. So arbitration was discontinued by many brokerages. And so when you see that paragraph C there, 22C, add in the agreement A or B if you want arbitration. We never, ever, ever, ever do that. Never.
Listen to Mark. He's paying attention. I'm not. Sorry, guys. I'm getting tired towards the end of this. And 23 is the entire agreement. This is the entire agreement. There's no other agreements. 24, ownership, title, and authority, that the seller's warranty, they have the authority to sell the damn place. 25 talks about legally authorized signer. This is the person that, if it's in a probate or a trust or an LLC, that they have the legal authority, or even if they're individual, they have the legal authority to sign the listing agreement, and they attest to that. And then this is new, the section where it's entity sellers. This was the updated portion.
This has made an update in the June release that's making it more in keeping with the format of the purchase agreement, where if you have an entity seller, you can have them complete this section and they don't have to then use the RCSD form. But the trick here is to complete this section correctly. So check the box that says entity sellers. And then if it's the name of the legally authorized signer, see how those fields highlight now? That is your clue that they need to be filled in. And so fill in the name of the legally authorized signer. If it's a trust, list the name of the trust in section 4. And then
So you would put, for instance, Joe Seller, right, Mark?
Correct.
And then you put the trust.
Mm-hmm. The Joe Seller Trust, or something like that's the legal name of the trust that it would appear on the face of the trust document. And then signature by would be where the digital signature would go. Printed name of seller, Joe Seller, and then legally authorized signer, and then title, if applicable. In this case, he would probably be a trustee. So you would put in the title section trustee. So the other thing to remember is that if you have a trust, you fill out 3 lines: signature by, printed name of seller, and printed name of legally authorized signer. If it's just a regular individual, it's just the first 2 lines: signature by and printed name of seller. Of course, if you have a second seller, then you'd add that information too.
You're talking right here, Mark. You would put Joe Seller, trustee.
Yeah.
Okay.
So I believe when you check the box entity sellers.
What's this over here though?
That's the title. So that would be the, trustee, successor trustee, or something like that.
So I wouldn't put it there. I'd put it over here.
Yeah, you can put it in that title field.
This is brand new. It just came out, you guys.
I believe when you check that box that says entity sellers in section 25, that it pre-checked the printed name of legally authorized signer for you.
It did.
Okay.
All right. And then you get the seller to sign. Right here is the additional signature addendum. Let's say you have more than 2 sellers, because there's only 2 sections for sellers to input their name. But what Mark recommends, you either use the form ASA or you can actually put, let's say you have 3 sellers. You could do it this way.
Try to squeeze them in. It makes it a little easier. And the reason for that is because the ASA form requires its use for every document that's subsequently signed. So you send a TDS and an SPQ, you need an ASA for that. You send them a mold disclosure, you need an ASA for that. And you can, have more than one form per ASA, but it's better to kind of squeeze in the signatures on that way. You can avoid using the ASA form if you don't need to.
Then the next section is broker signatures. This is not me, this is actually you guys. So you put your, I'll go ahead and fill in my stuff. But it would be your information. And then this box right here, 2 brokers with different companies are co-listing the property. So this happens very rarely. We don't like it because it kind of like figures out, well, who's running the transaction. But it does happen, especially on like luxury type properties. People might co-list with a luxury brand, even though we have our own luxury brand, or they might know 2 agents that I can't make a decision. Can you both represent me? You would check that box. And then the car form ABA would be incorporated. And the last 2 pages is the seller's advisory. And in a nutshell, this is basically an advisory to the seller. Hey, you're selling your home. Here's your general disclosure duties. Here's your statutory duties. Here's your death and other disclosure duties. If it's in a condo, here's your duties. Basically, it's just basically the seller's disclosures without boring you. But this is basically an advisory to the seller to make sure they read, which they won't 99% of the time, but you never know, you might have somebody that will. And it basically just outlines what their responsibility is during the sale. And then one last form, the California Consumer Privacy Act Advisory Disclosure and Notice. This came out December of last year because we needed another form in the Zip Forms library. But it basically is an advisory, disclosure, and notice for consumer protection. That is it. I think we're done. I think I put everybody to sleep on this call.
Who's on overload?
Yeah. Does anybody have any questions?
It's a lot to remember, and don't try and remember it all. Just remember where to go to get the answers when you get stuck.
So the links that we saved from the chat box that shows how to access all of the forms, including the PDF forms that aren't in the packet.
Well, it depends on the link that you're talking about, but the very first one, which was the initial documents, that is, those are documents that may be zip forms, may not be zip forms. For example, estimated buyer's cost. You can prepare an estimated buyer cost in zip form, or estimated seller proceeds in
like a
form.
net sheet?
Yeah, correct. That's another name for a net sheet, right?
So is that something we can get done through escrow?
They can do that for you too if you ask them in advance. And we recommend that you give one to the seller before they sign the listing agreement, because if you give them the net sheet afterwards, then they're already contractually bound, and they look at it and they say, well, I didn't know it was going to cost me that much to sell. Well, they're already in the contract. So this is why we ask you to give it to them ahead of time.
Okay.
All right, I hope you guys got something out of this today. It's a lot to
Thank you.
cover.
It
Don't
is.
know everything,
I had my nap during class.
but we
We'll
will
look forward
end
to
this.
seeing you in a couple of days for the next session.
See you guys all on Thursday. We'll cover the buyer broker agreement.